Hello, everyone. Welcome back for our fourth session of the Morrison Foerster and Nucleate Advanced Topics in Patent Law course. We had a great session last week and look forward to continuing these discussions over the next several weeks. Today's session will focus on patent strategies for personalized medicine and diagnostics, which will be led by Morrison Foerster Associate Rachel Rice and Scientific Analysis Liz Newman. Before we begin, I have a few brief housekeeping items to tell you about. If you have any questions during this 1-hour session, please use the Q&A feature on the Zoom screen. We'll do our best to get your questions answered during today's talk. If you have any technical difficulties, you can use the Q&A feature, but you can also send an email to Nora Moore at nmore@mofo.com. If there are any other topics that you'd like to hear about, please feel free to share those with us. We're happy to consider them for future presentations. The presentation materials from today's talk will be available at the end of the session on our website. Session 3 recordings, I'm told, are available now. And as a reminder, class office hours are available. We've had a number of the students in this class reach out to us, which has been great. If you're interested in an initial 30-minute consultation with a MoFo attorney or patent agent, please send an email to us and introduce yourself and the topic of interest, and we'll connect you with the right person. Finally, keep in mind that MoFo is actively recruiting patent agents, scientific analysts, and technical analysts. We also have an internship program for college and graduate students. For more information, see our recruiting website. And with that, I'll hand it off to Rachel Rice and Liz Newman, who will begin this discussion. I understand that Liz will be starting. Liz, please take it from here.
Thank you, Mike, for that great introduction. Rachel and I are both very excited to be talking to you guys today about patent strategies in the context of personalized medicine and diagnostics. So firstly, we just wanted to start with what is personalized medicine. And most simply put, this is the use of patient-specific information to make treatment decisions for that patient. For example, by using genetic markers or other biomarkers like the level of a certain protein, we can use that information to inform patient-specific therapies. And the way we gain access to this type of information is through the use of diagnostics and diagnostic technologies. And this really underlines the critical relationship between diagnostics and personalized medicine. So we have lots of technologies in our toolkit when we talk about personalized medicine. And these include things like medical devices, pharmaceuticals, genomics, proteomics, any omics that you can think of. Even in the last 5 years, with the expansion of next generation sequencing and other molecular biomarker analyses, these technologies are becoming more advanced and also more affordable. And that includes things like high throughput analysis of all of this wealth of information. So things like bioinformatics and the computer software that's associated with those types of analyses. So once we have this information, the real question is, what does personalized medicine look like in an application? What do we do with this information? And we use it to make decisions about treatments for patients, including eligibility of patients. So who should be receiving what types of therapies at what doses? And even if there are specific patient populations that might be eligible for additional monitoring or preventative measures like screens for certain genes associated with cholesterol, for example. And all of that comes together to create some kind of unique patenting challenges for personal medicine. And Rachel and I have kind of broken these up into two large topics. So the first is subject matter eligibility, and that's where we'll start our presentation today. And then we'll wrap up the presentation by talking about potential infringers. So when we talk about subject matter eligibility, we first look to USC 101, and this is a threshold inquiry. that is done before assessing other patentability requirements, such as novelty or non-obvious. And here, what we see is whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore. So when we think about subject matter eligibility under 101, we think about process, machine, manufacture, compositions of matter, or new and useful improvements thereof. And there are, of course, judicial exceptions to this. And these include natural phenomenon are not patent eligible. So things like naturally derived animal and plant products that are unaltered are not eligible for patent protection. Abstract ideas are not patent eligible. So algorithms, mathematical formulas, mental processes. And then the last judicial exception are laws of nature. And this is something that we'll come back to several times over the first part of this presentation. So for example, correlations that occur in a natural setting are not patent eligible. So these being our three judicial exceptions, prior to 2012, USC 101 was interpreted quite broadly. And here's a quote that I think sums that up really nicely. Congress intended statutory subject matter to include anything under the sun that is made by man. So in order to kind of examine what changed in 2012 and where we stand today in terms of subject matter eligibility in 101, we wanted to look at a couple of landmark cases in this area. And the first one that we wanted to talk to you guys about today is Mayo v. Prometheus. So this case has to do with a class of drugs known as thiopurines, which were known to be useful in treating some autoimmune diseases. And it was also known that these drugs are metabolized into many different metabolites, and metabolites thereof were known to correlate with efficacy and/or toxicity of the thiopurine drug. And so the patent at issue here, and I'll show you the claim on the next slide, the patent at issue here has to do with a diagnostic method related to measuring metabolites of the drug to control the effective drug dose. So in essence, if the metabolite level is too low, it's considered that the drug is not effective. And if the metabolite level is too high, it's considered that the drug could be toxic and have toxic side effects for the patient. And so here, the inventors identified the exact levels of this particular metabolite that correlates with the therapeutic efficacy or toxicity. So here's what the claim looks like. It's a method of optimizing therapeutic efficacy. It has two steps, an A and a B clause. In the A clause, we administer the thiopurine drug, and in the B clause, we determine the level of the metabolite, wherein if the level of the metabolite is less than a certain level, that indicates a need to administer greater amounts of the drug. And if the metabolite is above a certain level, that indicates a need to decrease the amount of drug. So in this case, the issue here is whether this patent was invalid for containing ineligible subject matter under 101. So the court had to determine whether the claimed process transforms the natural law sufficiently such that they were patent eligible applications of that natural law. So first, the district court reasons that the patent was invalid because the natural law that they're referring to is the correlation between the metabolite level and the efficacy of the thiopurine drug. Eventually, the Federal Circuit reversed that decision, stating that in addition to the laws of nature, this claim also had the administration step and a determination step that sufficiently transformed this away from a law of nature. However, the Supreme Court reasoned that these same additional steps were not sufficient to transform the claim. So the Supreme Court found that the administration step of this claim in Clause A only serves to limit the claim to a particular audience or determine the relevant audience. So that's doctors who are treating patients with an autoimmune disorder. And limiting the law of nature, the correlation between the metabolite and the efficacy to a certain environment or technical environment is not sufficient to grant patent eligibility to those claims. And the determination step in Clause B simply tells the audience to determine the level of the metabolite through whatever process they want. And because there were many routine processes out there for determining metabolite levels, this step was thought to be well understood, routine, conventional activity that was not sufficient to transform an unpatentable law of nature into a patentable application. So the Supreme Court ultimately determined that simply appending conventional steps specified at a high level of generality to laws of nature, natural phenomenon, abstract ideas cannot make those laws, phenomenon, and abstract ideas patentable. So in essence, the determining step in this claim was too general and covered all processes that would make use of this natural relationship between the metabolite level and the efficacy of the drug. So after a subsequent Supreme Court case, also dealing with 101, and that's Alice v. CLS Bank, the USPTO released new guidance for determining subject matter eligibility. So the Alice-Mayo test was used to determine whether an invention was patentable. And if we look at the Alice framework, the first step within the Alice framework asks whether or not the claim is directed to a law of nature, natural phenomenon, or abstract idea, i.e. one of the judicially recognized exceptions that we went over in the beginning. If yes, then the second prong of this test asks whether the claim recites additional elements that amount to significantly more than what the law of nature, natural phenomenon, or abstract idea is. So under these USPTO guidelines, additional elements in this step must not be well understood, routine, or conventional activities, as the level, determining the level of the metabolites in Mayo was found to be. So the court's motivation was to ensure that no one gets a monopoly to an abstraction, which is important. But what we saw after this decision was just a huge graveyard of invalid cases because of findings that claims were not patent eligible under 101. So Rachel and I thought it might be useful to take a look at some of these cases in the graveyard and examine why they were found invalid and perhaps what could be done with claim construction to change the outcome. So the first case in our Alice-Mayo graveyard is this Myriad decision from 2013. And here the claims are directed to an isolated DNA encoding a BRCA1 polypeptide. So what amounts in essence to an isolated gene. And in this case, this particular BRCA1 gene, BRCA2 gene are associated with some types of cancer, most specifically breast cancer. So the claims were found not to be patent eligible as the isolated DNA is found to be the same sequence as is present and naturally occurring in humans. So here we see it is undisputed that Myriad did not create or alter any of the genetic information encoded in these genes. The location and order of nucleotides existed in nature before Myriad found them, nor did Myriad create or alter the genetic structure of DNA. Instead, Myriad's principal contribution was uncovering the location and sequence of the genes within the chromosomes. So here we have what is a groundbreaking and innovative discovery that absolutely shifted our understanding of the relationship between genes and cancer and what personalized medicine applied can do to improve patients' lives. But that in and of itself does not satisfy the 101 inquiry. And interesting to note here, later it's been found that claims to complementary DNA or cDNA are patent eligible. And that's because cDNA is DNA that is sequenced from messenger RNA and is devoid of exons. And that happens in a laboratory setting, and cDNA is not believed to be naturally occurring. And so therefore, those claims are patent eligible and are considered to be sufficiently altered. So the next case is another really good example of something that was groundbreaking and important scientifically, but was similarly found to be patent ineligible. And this is Ariosa v. Sequinome. And here we have methods that recite detection of cell-free fetal DNA. So prior to this discovery, genetic testing in utero of a fetus for sex determination, karyotyping, genetic marker risk analyses, etc., required amniocentesis, which is a highly invasive procedure to extract amniotic fluid using a very long needle. And in addition to being very invasive and painful, the procedure is also known to increase the risk of miscarriage. And so here, the inventors have found a way to find the fetal cells that are circulating within the mother's bloodstream and distinguish these for genetic testing. So now, testing of the fetus's DNA and genome could be done much earlier in pregnancy and with significantly less risk to the mother and also significantly less invasive procedure. However, the courts found that the claims started and ended with a naturally occurring phenomenon, which is the presence of fetal DNA within the mother's circulatory system. And I'll close the loop on this case actually in a couple of slides when we come back to this and discuss how these inventors, Sequinome, were able to get patent protection of this concept by using different claim language. So finally, our kind of last example in the Alice-Mayo graveyard is Athena. And so here, very similar to our other cases, the claims relate to the presence of a neuromuscular antibody specific to a specific kinase, so that's MuSK. And this autoantibody would only be present in patients with a specific disease pathology, with a specific autoimmune disorder. And again, however, the courts reasoned that this is a naturally occurring phenomenon, and the methods of detecting antibodies as recited in the claims were well known in the field, and therefore this was also found to be similarly ineligible under 101. And so while those cases represent claims found ineligible of 101 in our graveyard following Mayo in 2012, we also wanted to talk about some other landmark cases where claims were found to be patent eligible. So we will review a couple of these now. So after this long line of decisions finding many of these diagnostic-based claims to be ineligible, the Federal Circuit has recently found certain types of diagnostic method claims to be patent eligible. And so firstly, we wanted to discuss this case, which is Vanda Pharmaceuticals. So the claims at issue here were directed to the identification of a genetic variant that renders individuals poor metabolizers of a compound used to treat schizophrenia. So it's a CYP enzyme variant, this CYP2D6. And from identifying whether or not the patient has this variant, administering specific and different amounts of the compound to individuals. So first, the district court reasoned that although the claims were in some ways directed toward a law of nature, and so that's the relationship between the drug, its metabolism, and the variant, and whether or not the patient has that variant, the claims also added a step of genotyping the patient for CYP2D6 for this variant in metabolism to determine the appropriate usage of the drug. So the district court did not find that this particular genetic test for this CYP enzyme was routine or conventional, and therefore the claims were not invalid under 101. On appeal, the Federal Circuit did agree with the district court and reasoned that the claims in this patent were not really directed toward a natural law. And here the court distinguished this case from Mayo by reasoning that these claims instead were directed toward a novel method of treating a person with a specific drug, and not a diagnostic method for looking at this genetic variant. The claims were not directed toward the relationship between the drug, the metabolism, and the variant, but to the application of that relationship. So here the claims are directed to a specific treatment of a specific patient using specific compounds at specific doses to achieve a specific outcome. And that application is something we'll talk about quite a bit. So very similarly, in endopharmaceuticals, these claims were directed to treating pain in a renally impaired patient with oxymorphone, wherein the creatinine clearance rate of the patient was measured, and a lower dose of the compound was administered to the patient depending on the patient's rate of creatinine clearance. So the natural law that we're talking about in this patent is the correlation between the blood concentration of the drug over time and the functioning of the kidney as measured by the concentration of creatinine that's excreted into the patient's urine. On appeal, the Federal Circuit did hold this patent valid. And in fact, the court compared the claims in this endo patent with the claims in the Vanda patent, and found that the claims at issue here in endo are indistinguishable from those that were found and held valid in Vanda. And the court also pointed out that while the Mayo patent was not directed to the application of a drug to treat a particular disease, this endo patent, again, was directed toward a specific application of the natural law. So an application of the relationship with specific steps on whether to adjust or lower the dosage of the patients based on their creatinine clearance. So the court found that the claims at issue in both of these cases, in endo and in Vanda, to be patent eligible. And we come back to this point again, which is that the claims are directed to a specific method of treatment for specific patients using specific compound at specific doses to achieve a specific outcome. So we thought it would be a useful and helpful exercise to kind of compare and contrast two cases, one in which claims were found to not be patent eligible and one in which claims were found to be patent eligible. So this is that same Ariosa-Sequinome decision that I promised I would come back to from a few slides ago. And so again, the Federal Circuit held that claims directed to a method of detecting fetal DNA in a mother's serum or plasma sample were not eligible as being directed toward a natural phenomenon. In its opinion, the court even acknowledged that the discovery of the cell-free fetal DNA in the mother's circulating blood was a major scientific breakthrough, as we discussed, but still, they ultimately found the claims to be primarily directed toward a natural phenomenon. So merely conventional techniques for detecting DNA failed to transform those claims into a patentable invention. But very interestingly, in a series of patent applications related to those, Sequinome obtained 2 patents, which are now exclusively licensed by Illumina. And these are to methods of preparing a fraction of DNA enriched in the cell-free fetal DNA, so the fetal DNA. So the difference here is that the claims recite steps of extracting DNA, producing DNA fragments by size discrimination, and selectively removing DNA fragments larger than a particular size, and then analyzing the remaining DNA fragments. So the methods of preparation this method of preparation is based on the inventor's finding that the DNA fragments, the fetal DNA fragments, are on average significantly smaller than the maternal DNA fragments, which is a natural phenomenon. But by selectively removing DNA fragments larger than 300 or 500 base pairs, the inventors were able to enrich the sample for fetal DNA. So interesting and notable here is that these two granted patents, now licensed to Illumina, were very deep into prosecution at the time that this related sequenome patent was found invalid in 2015. And so during prosecution of these two other patents, the preamble of the originally filed claims reciting a method of analyzing DNA fragments was amended because they did in fact receive a Section 101 patent ineligibility rejection during the course of their prosecution in the United States. And so instead, they amended their claims to recite a method of preparing a DNA fraction along with these other active steps of producing DNA fragments and selectively removing DNA fragments. So these amendments, which incorporated these very active and defined steps, rather than the previous passive and generic steps, may have also laid the foundation for the Federal Circuit's finding that the claims are in fact patent eligible. And it's important to note here that those thresholds, the 300 to 500 base pair cutoff for fetal DNA, those threshold cutoffs are human invention. And the inventive aspect for this granted Illumina patent was determining and applying that discrimination. And so now with this, a little bit of judicial background, I'm going to hand this over to Rachel.
Thanks, Liz. Okay, so while Liz is...
Rachel, it's Mike.
Yep.
Before you start, we got a couple of questions. Maybe the two of you guys can handle. Have you seen them, Rachel?
I have, yeah. I was actually going to hit on them before we go on. So that's perfect. So we had a couple questions come in while Liz was presenting related to subject matter eligibility. The first one is asking if recombinant DNA is patent eligible. So recombinant DNA, because it's not naturally occurring, generally is going to be patent eligible subject matter. With that being said, it doesn't necessarily mean it's patentable. It still has to get over the other hurdles, such as being novel and non-obvious, but it would generally be thought to be patent eligible subject matter. Another question or comment that came in was that with relation to the endo case that Liz presented, adjusting a dose of a compound based on renal function doesn't seem like it would be an uncommon phenomenon. And I think that statement is absolutely true. And so, you know, it leads to the question of, would endo be essentially tying up the ability to kind of therapeutically monitor and dose? And I think the part of the court's motivation for finding the claims patent eligible in endo was that they were limited to a bit more specifics. So for example, the patient population was a renally impaired population. So it was comprised of patients who had already been identified as being renally impaired. And then there were some more specifics of particular thresholds, and based on those particular thresholds, whether you would give specific dose amounts. So it wasn't just like in Mayo where you would give a higher dose or a lower dose, but it was adjusting to more particular doses. And so that, I think, helped assuage the court's concerns that a claim like that could, you know, just tie up and create a monopoly to this broad idea. Finally, we have the third question, and this is a great question and something that I definitely didn't know going into law school. When you see case titles, who is listed first, the person who's suing or who's being sued? So normally if you're in trial court, the first name listed is going to be the plaintiff. That's the party who brings the suit. And then if you're in a court of appeals, the first name listed is going to be the appellant or the person who is bringing the appeal. Yeah, great question altogether. And we'll keep monitoring for other questions as we go. All right, so now that we have gone through some of the claims that were found to be patent non-eligible and patent eligible, I am going to move on to where that brings us now. And I'm just going to make sure that I can control the slides. There we go. Okay, so following all of these cases from about 2012 to 2019, the Patent Office realized that it would be very helpful and practical to release some subject matter eligibility guidelines that would help patent practitioners draft claims that they could understand would be more likely to be found patent eligible. So the most recent formal guidelines that they have released were in 2019, though they have made some slight updates since. And based on all of the court decisions, what the Patent Office advised is thinking back to that Alice-Mayo test. I think I have lost the presentation on my screen, but I'm going to take a beat and if okay. Apologies, everyone. Liz, are you able to share your screen? I'm no longer seeing it. Okay, great. I think we're back. Okay. We are back in action. So thinking back to that Alice-Mayo test, you're going to ask if the claim is directed to one of those judicial exceptions that we talked about. So that's going to be things like abstract ideas, natural phenomena, and laws of nature. And you're going to ask, is that judicial exception integrated into a practical application? And if it is, then that is where you stop. Your claims are going to be subject matter eligible. And for all the reasons Liz went through, that practical application is most commonly going to look like perhaps a specific patient population, a specific compound for the treatment of a specific indication, and at a specific dose, things like that. Those are what the Patent Office is saying are practical applications. If, however, your judicial exception is not integrated into a practical application, then you would go on to step 2B of the Alice-Mayo test, and that is asking whether the claims recite additional elements that amount to significantly more. And that's really your inventive concept. And I know significantly more is not the most precise definition, but the Patent Office has said that things like routine or conventional steps are not going to give you that significantly more aspect to get you over this patent subject matter eligibility hurdle. Importantly, I think it's critical to stop and realize that even though this is PTO guidance, it is not binding on courts. So if you follow these guidelines from the Patent Office, it can certainly help you get claims allowed and granted from the US Patent and Trademark Office. However, it doesn't mean that if your claims were to be litigated in a court, that just because the Patent Office found them to be eligible, that the court would also find them to be eligible. The court is not bound by the PTO guidance. Okay, there have been some recent developments with respect to subject matter eligibility at the PTO, and so I just wanted to hit on these as well. So as of yesterday, the PTO began a pilot program to defer the question of whether claims are subject matter eligible until all the other inquiries about the claims have been resolved. So this is in contrast to what Liz told us at the beginning of this presentation, that normally subject matter eligibility is a threshold inquiry by the Patent Office. And normally the Patent Office does something called compact prosecution, where essentially they make it a point to raise all the different objections and rejections to your claims from the get-go. Otherwise, prosecution of your patent application wouldn't be efficient because you could just be going back and forth on a couple issues here and then a couple issues later. And so kind of Against the normal backdrop, the Patent Office has said, we will deal with subject matter eligibility in our pilot program at the end of things. And there's really kind of two different motivations or reasons why this could make sense. So first of all, the Patent Office is going to go through all the other inquiries for your claims. They're going to look at them and ask if they're novel and if they're non-obvious, if they're sufficiently described and enabled. And during all of that, it may become clear that your claims don't satisfy one or more of those criteria, which would effectively render the subject matter eligibility inquiry moot. The other option is that by going back and forth with the Patent Office and explaining why your claims are particularly not obvious, it might become clearer where the ingenuity and the significantly more aspect is, such that by the time you get through all of that discussion with the Patent Office, it is clear that your claims should be subject matter eligible. So like I said, this just started yesterday. The Patent Office will invite a number of applicants to participate in this program if they want to, but it just started yesterday, so we will have to see how it goes. So where does all of this leave us? In terms of subject matter eligibility takeaways, it's important to recognize that patent eligibility is still in flux in the US. Over the last decade, we've seen major changes in the law for Section 101, and we're probably going to continue to see more. Also, it's important not to forget that these considerations are specific to the US. Patent eligibility and patent eligibility of diagnostic methods really differs country by country. In a number of countries and major patenting jurisdictions, diagnostic methods as applied to the human or animal body are not going to be patentable, although you may be able to reformulate your claims accordingly. So you just need to bear that in mind. And in terms of thinking about how you can draft your patent application and your claims better in light of these concerns, we think there's a few tips to take here. So the first one, when you're drafting your application and claims, of course, really focus on those practical applications that these courts have talked about, the specific patients, compounds, doses. Also include lots of description in your application of how your claimed invention is improved and addresses the challenges or problems seen in the prior art. When you are talking to the patent office or a court and trying to convey that there really is something more to your claims, you can point to what was in your application to show the really truly inventive aspect of it. Finally, when you go to draft a patent application, that is going to be the application that you use in different countries and different regions, most likely. And so because patent eligibility can differ in different countries, and also eligibility law can change over the course of time, it's really helpful if you can draft kind of a varied set of claims that have methods of treatment, diagnosis, detection, or preparation, like we saw in the last Illumina case. And so that's kind of a way of hedging your bets, if you will, and kind of hoping that at least if the law changes in the future, you're covered in one way or another. All right. So that wraps us up for patent subject matter eligibility. And now we're going to move on to a second consideration, another patent challenge for personalized medicine, and that is capturing infringement. And the section will be a little shorter. All right. So in thinking about capturing infringement for diagnostic type claims, you want to think about something called induced and divided infringement. So oftentimes, induced infringement is where, for example, a drug maker might prescribe prescribing instructions saying that you should follow certain steps of a method claim. And so they're inducing others to take those steps. And this brings up something called divided infringement that we will talk about. Okay, so a lot of times you are drafting your patent claim to try and make sure that it is subject matter eligible. And so you'll draft it as a multi-step method claim. There could be a step of detecting or measuring something, and then another step of administering a compound, for example, based on that measurement or the detection. And so you have these multiple steps. Well, induced infringement typically requires you to show that a single actor performed all the steps of the method claim. But that can be a bit of a problem because in reality, a lot of times you have something called divided infringement. And that is where multiple actors are carrying out different steps of a claim such that no single actor is performing all the steps. So just as an example claim here in clause A, we have an active step of measuring a metabolite. And then in clause B, we have another active step of administering a compound at a certain dose if the metabolite is above a certain level, or administering the compound at a different dose if the metabolite is below a certain level. And so it's probably fairly obvious that on the ground in practice, it's going to be perhaps a diagnostic laboratory that is measuring a metabolite in a blood sample, for example, and then it's going to be a doctor that's actually administering the compound. And so here you do not have one actor carrying out all the steps of the method. And so it would be more difficult to show induced infringement, but there is a way. So in the case where you have divided infringement, you have multiple actors carrying out the different steps of your method, you have an additional hurdle. You would essentially will have to show that a single entity is responsible for the infringement. So it could be that one of the actors in the method steps is directing or controlling the performance of the other actor in the method step, or the different actors form a joint enterprise with each other. So if you're thinking about, for example, a diagnostic laboratory and a physician, they're most likely not going to be in a formal joint enterprise with one another. And so to show induced infringement, you're going to have to show that one of the actors is directing or controlling the other's performance. And that is just a heightened burden on you to show that someone is infringing your method. So how can you get around this so that you don't have to show that two different people are essentially acting in concert together to carry out the steps of your method? So if we think back to this example claim, it has two active steps. Like I said, it's potentially a diagnostic laboratory measuring the metabolite, and then a physician administering the compound. Alternatively, you could draft this claim to have a single active step. For example, in our after claim here, there is only one active step of administering the compound to a subject previously identified as having a metabolite level within a certain range or at a certain value. And so you've essentially here removed that active step of measuring the metabolite level so that your entire claim can be infringed by one actor here, which would be the physician. And of course, it's not necessarily that you are trying to pursue infringement by the physician, but it would be that you could pursue infringement by the, for example, drug company that's issuing the prescribing information to the physician. And so you can just think about this because sometimes claims, they could have steps that are active steps carried out by the diagnostic laboratory, the patient, or the physician. And you just want to consider, how can I redraft this claim in a way that there is really only one actor? So to that point, like I said, many different actors could be involved in personalized medicine. And if you're thinking about how should I draft my claim so that there's only one active step, or so that the steps are only carried out by one actor, you might want to have some further considerations about really what steps you want to capture in your claim, and if you actually can capture infringement. So for example, if a patient is carrying out certain steps at home, or a physician is carrying out certain steps in a laboratory, you might consider which steps would be easiest to actually detect and to know that someone is infringing my claim. And if one of those steps would be a lot easier to detect than another, then that might be the one that you want to draft your claim to capture, because then you will more easily be able to identify when someone is infringing your claim and taking action. So these are just some basic drafting tips to help you think about how your claims can not only be subject matter eligible, but also avoid this heightened burden of divided infringement and having to show that multiple actors are acting in concert with one another. So I think that about wraps it up for our presentation today. It looks like a few more questions have come in. I have not had a chance to look at them yet, but if Liz or Mike has and wants to take the lead on that, that would be great.
Well, let me read this one to you, Liz, and I think you can answer. Using a diagnostic method. So this is the question of infringement. You have a claim to one diagnostic marker, and the method, the potential infringing method, is using that marker plus 4 or 5 other markers. Is that still infringement?
Sorry, let me make sure I understand your question. So whether or not additional markers being required changes the infringement calculation?
Correct.
I mean, I think it would, Rachel.
Yeah, there's 2 sides of the coin here. So I think the way the question was asked, if let's say that, essentially one biomarker is claimed and you are using that biomarker and 4 others, are you infringing?
That's
yes.
infringement. Yeah,
yes,
that's a yes.
You have met the only limitation of that claim. On the flip side, if the claim is to 5 different biomarkers and you're only using 1, you're not infringing because you haven't fulfilled the other 4 aspects of that claim.
Yeah. There's another more complicated question down here, and I can take this one. So this is one. So if you write claims with very specific doses to 200 mg per day, can someone just get around them by using a slight variation of doses, 205 milligrams a day? And the reason I grabbed this one is this is a complicated question. And the answer, you're going to get a lawyer's answer, which is it depends. So what does it depend on? So it depends on what happened to those claims during prosecution. If you wrote those claims during prosecution and they got amended such that the amendment changed whatever range that you had down to 200 mg per day, then that claim is limited to 200 mg per day. And someone using 205 would not literally infringe that claim. All right. However, if you wrote a claim that was to 200 mg per day, you started with that, and it went through the patent office, and the claims were never amended. So they started out at 200 mg per day, and the wording of your claims is essentially the same as where you started and where you ended. And then I'm suing Rachel for infringement. All right. Not only so her defense would be that, well, I'm using 205. And I'd say, yeah, that's not, you avoid literal infringement. But I would argue that she infringes under a doctrine called the doctrine of equivalence. This is a fairness-based doctrine based in equity. And it says that if you have an amendment, the only time it applies is if you get a claim that hasn't been amended during prosecution. So this is why we often talk to clients about writing very narrow claims that cover specifically what you're doing and getting those granted without examination, right? Because that claim can be very, very valuable in this circumstance, because 205, as the question proposes, is essentially equivalent to 200. So under the doctrine of equivalence, you would have coverage for 205 if you did not amend the claims. If you amended the claims, you lose all equivalence and you're out of luck. This is a very hot area in the biotech space these days, is the scope of the doctrine of equivalence, how to get claims that are covered this way. And it's a very exciting area. If you have any other questions.
I think that there's a great question here. What is exactly patent eligible about gene therapies? Is it the entire construct sequence, gene plus backbone? how different does the gene sequence have to be in order to be considered new? Seems like it would be difficult for gene therapy patents to protect from competitors. So I think this is a really good question that brings up a lot of things that we've talked about today. You're right that, you know, if you wanted to do a patent similar to the BRCA, to that we discussed at the beginning, but often what we're talking about when we look at gene therapies and claims for gene therapies are claims to a method. So what are the patients? Who is the patient population? And then your point about the gene itself is also true. There could be patentably valuable, distinct, innovative aspects to the vector, to the promoters, to how it's delivered, there's all types of aspects of gene therapies that can be explored as patent eligible. But you're right that if I wanted, you know, just to get a patent directed to the cystic fibrosis gene, that's not going to work. But absolutely, there's room for different types of constructs and different methods and different patient populations in that space.
Hey, Rachel, why don't you take this question here regarding methods? So someone is concerned that, you know, people have patented methods where there are prior publications that might have disclosed it. And maybe you can answer this in the context of first the disclosure requirement, the IDS requirement during, the patent application process, and then how once a patent grants, what are the options for somebody to attack a patent?
Yeah, absolutely. So when you apply for a patent at the patent office as kind of a threshold issue, you have a duty of disclosure. And what that means is that anything that might be relevant to the patentability of your application, and that can mean that it could be relevant to whether your claims are novel or non-obvious, you have to disclose to the patent office. So with that in mind, in theory, and if someone is fulfilling their duty of disclosure to the patent office, if they are applying for a patent application and they are aware of a previous publication that's relevant to the patentability of their claims, then they should disclose that. And the examiner at the patent office should take that into consideration. There are some exceptions to this. So for example, if you publish a paper on your method, and then within 1 year in the US, you claim the same method, that prior publication, as long as it was made by the same inventors and is about the same method, is going to be accepted. It won't necessarily be held against you. However, that's called a grace period disclosure because it's really that 1 year leading up to the application. But that grace period disclosure, importantly, is US specific and does not necessarily apply in other jurisdictions. So that's not something you want to count on. Now, if you're on the other side of this and a patent has granted and you're aware that a publication has issued prior to the filing of that patent, which essentially makes that patent's claims not novel, then there are some different steps that you can take. Actually, if you become aware of this before the patent grants, within a certain time period, you can submit that publication to the patent office, and you can do so on an anonymous basis so that the examiner actually says, oh shoot, I missed this publication, it's highly relevant, I need to take it into consideration. And maybe because of that, those claims won't go on to issue. Alternatively, you can file different actions with either the Patent and Trademark Office or with a district court to try and invalidate that patent based on that prior publication.
That's great. Thanks, Rachel. There's a question on CAR T-cell therapy, and I don't know, Rachel or Liz, if you wanted, we're going to have a whole class on this coming up next couple of weeks, but if you want to just briefly touch on that, I know you guys do a lot in that space.
Yeah, I guess it's probably sufficient to say that we do a lot. Rachel and I both, Morrison and Foerster, generally work significantly in the CAR T-cell space, and so please keep an eye out for that dedicated session because it is worth having its own session about.
Yeah, and I think just with that being said, a lot of the considerations for how to claim and get granted claims to a CAR T-cell therapy are going to be similar to what Liz highlighted for gene therapy. So it could be something about your genetic construct that's patentable. Potentially there's a better promoter, or your binder just expresses better, or you know, there's some aspect of engineering that vector which is new and non-obvious. Or you could also try and get claims to the methods of, for example, treatment. So very, very similar considerations to gene therapy that Liz touched on.
Oh, Rachel, what if an inventor discovers another patent application that was available at the time that you filed your provisional patent application, but you only found it after you filed the provisional, but before the PCT? It sounds like you've written a patent application, you filed it, and then you find some relevant art before your PCT. What are your options at that stage?
Yeah, so it sounds like you've started your patenting process, you've filed your first provisional application in the US, you haven't yet kind of finalized and locked down your application at the international stage, and then you become aware of this prior art that is really similar or the same as what you're doing. So first of all, going back to what I talked about earlier, you still have that duty of disclosure. So if you go through with this patent application, you will have to disclose that publication you found, or that patent application you found, to the patent office. So don't forget that. But another consideration, you know, there's a lot of art in all of the spaces we work in. And I think it shouldn't be discounted that even seemingly small changes can make huge differences and lead to patentability. And so you can consider, before you finalize this application and move towards this international stage of it, are there additional data and findings that I can include? Can I add different claims to cover different aspects? But it's important to note that when you add these new aspects to your patent application, it's going to get you a new priority date. So all those new claims you add, they're only going to be effective basically as of the day you added them. You can't claim the priority date of that first filing because that information wasn't in there at the time.
That's great. All right, we're up against 2 o'clock. Thank you, Rachel. Thank you, Liz. Thank you to all the attendees, and we'll see everybody next week. Thanks a lot.
Thanks, everyone.
Thanks, guys.